I'd like to reserve 6 minutes for rebuttal, if I may.
Very good.
May it please the Court, my name is Brian Trulot. It has been my privilege to represent Agnes Scott College in the litigation that is before the Court today. This Court's February 2nd, 2015 order, which remanded this case to trial court, reiterated the long-standing rule governing vicarious liability of private employers for torts arising from the execution of public functions by their employed police officers. It said, when this Court sent it to the trial court, when the complaint's allegations are construed in the light most favorable to Hartley, the plaintiff in this case, Agnes Scott College has not established that Hartley could not possibly present evidence that the campus policemen were acting under the direction of Agnes Scott College at the time of their allegedly tortious conduct. In other words, for the plaintiff to hold Agnes Scott vicariously liable for the actions of its employed police officer in this case, Lieutenant Antonozzi, she had to be able to present evidence at trial that Lieutenant Antonozzi, when he was engaged in his criminal investigation, which resulted in the warrants for Ms. Hartley's arrest, that he was acting under the direction of Agnes Scott College, that they somehow directed or controlled his criminal investigation and substituted their judgment for his training and experience when he was engaged in the criminal investigation.
Well, let me, you're sort of invoking, I guess, the law of the case rule in that argument.
Yes.
As I understand the posture of the case, the question before this Court at that point was whether, in light of the Supreme Court's preceding decision, your client, the college, was entitled to judgment as a matter of law on vicarious liability. There's no question pointing in the opposite direction, no argument that the plaintiff was entitled to summary judgment on that point. And so it was sent back down for consideration of that. And there's law about what vicarious liability of an employer for employees' conduct is. It seems to me stretching, and this is where you're saying something to push back on, seems to me that you're stretching the law of the case too far to read into what's written there a suggestion that we're implying a different rule regarding vicarious liability than would otherwise obtain.
So it is a different rule when you're discussing an employed police officer. And
right. I mean, we have that issue, but you're, and I know we'll get to that in just a second, but it seems to me that taking that fairly general language and suggesting that changes the law of employee of an employer's vicarious liability for an employee, I am highly skeptical of that argument.
So, Judge, when this Court issued that opinion is not written in a vacuum. It said you have to present evidence that Agnes Scott College was or that Lieutenant Antonozzi was acting under the direction of Agnes Scott College at the time of his alleged tortious conduct, because the law of this state since 1914 in the Pounds decision, which is a Georgia Supreme Court decision cited in our brief, has treated employed police officers differently than typical employees.
Let me go right there if I can. Any of these cases, and I'm certainly aware, we're all aware of all of these cases that deal with, typically they're bar situations where police officers are hired and they remove somebody and or make an arrest and the bar gets sued or the restaurant or whatever. In any of those cases, if there's any way to know, were we dealing with police officers that worked for a private entity in their policing job as opposed to a public entity where they would already have immunity under the Georgia law for their public policing functions? Because, I mean, you know what happened in this case originally. So this is my reversal day, because I got reversed in this case as well. And the Supreme Court said you don't have immunity under the Georgia statute when you're a police officer working for a private college, because that's not a state institution. So I wonder if it's a difference. I wonder if these cases that are out there are different because the police officers were police officers for municipalities and counties and maybe for the state, as opposed to a municipality or a police officer for a private college.
So to answer your question, Judge, you're right. This case is unique. The cases that we've cited in our brief deal with police officers that are employed by other city public agencies, the city, county, sheriff's department, And that is true. That is a difference in this case. But the fact that Lieutenant Antonozzi in this case was full-time employed by Agnes Scott doesn't make a difference. The Pounds v. Central Georgia case does not make a distinction around the fact that the police officer was employed by the railroad in that case. In that case, the police officer was appointed by the city of Savannah, but employed full-time by the railroad. And it focuses not on...
Isn't that the key difference, though? I mean, you said, well, employed by the city of Savannah, but I know that's 1914, but in this case, the statutory language is pretty clear about working for a political subdivision or a municipality. Why is it different?
Well, it's different because the Pounds case focuses on what the police officer is doing. In other words, it specifically recognizes that police officers working for a private entity may have a dual purpose. They may have duties that they perform for their private employer, and they have functions that they perform on behalf of the state.
So, but see, now let's go back to Hartley 1. That was the whole basis that opinion came out, was that from the Court of Appeals is that the police officer at Agnes Scott was enforcing Georgia law as he thought it should be enforced. And the Supreme Court said, well, but yeah, he was not doing it for the state. I argued that the exact same point in that opinion, and the Supreme Court didn't care about that. So, that's why I wonder if it's different, because yes, he's enforcing the law, but he's not doing it for the state. That's what the Supreme Court basically said.
And Judge, I think this is an important distinction. The Supreme Court said that he was not acting on behalf of a specific state entity.
Yes.
So that's the distinction where it took Agnes Scott, took the police officers out of the protections of the Georgia Tort Claims Act, because there was no evidence that the police officers were acting on behalf of a state entity. But that doesn't
just on the state.
But that doesn't mean they're not acting on behalf of the state.
Okay, but look, I'm with you. But that's not. But look, the state is the ultimate entity, right? I mean, it is. Every city and county comes from the state of Georgia. I mean, we charter them, or the state General Assembly charters every county and state. If they don't do it, there's not one. So I just don't know how we draw that distinction in light of the decision in Hartley too.
Well, and again, Judge, I think it's because the Supreme Court was focused specifically on whether there was immunity under the Georgia Tort Claims Act, and it found there could not be immunity under the Georgia Tort Claims Act, because in order to have that immunity, you have to be acting on behalf of a state entity. That is different from, are you acting on behalf of the state? And when you're talking about traditional principles of premises liability, employers can be liable for the actions of their employees when they're acting in the course and scope of their employment and in furtherance of their master's business.
So let me give you another hypo that I think would be more apt. And a city of Atlanta police officer is not in the city of Atlanta. You would agree if he or she sees a crime that's committed in Fulton County, that as a post-certified person, they still have an obligation to respond to that, right?
Yes.
Okay. So when they make that arrest in Fulton County, or they stop the alleged criminal in Fulton County, they're not doing it on behalf of the city of Atlanta that hired them. I would assume they're doing it on behalf of the state law that they're in charge of enforcing.
I would agree with that, yes.
Okay. So then how do they have immunity because they're working with the city of Atlanta when they're not really working for the city of Atlanta when they make that arrest in Fulton County?
And Judge, I don't know that they would have immunity under the Georgia Tort Claims Act. They may have immunity under the state constitution, which provides some other issues of qualified immunity. But the difference here is that when you are talking about vicarious liability, and the reason that police officers are treated differently is because traditional vicarious liability, you're acting in the course and scope of your employment and in furtherance of your master's business. Police officers are different. When you're talking about Lieutenant Antonozzi conducting a criminal investigation into an allegation of sexual assault, he may be acting in the course and scope of his employment with Agnes Scott because he's hired as a post-certified police officer. But when he's conducting a criminal investigation, he's not acting in furtherance of Agnes Scott's business. Instead, he's acting in furtherance of the state's business, because Agnes Scott's function is not to engage in law enforcement. Its function and its mission is the education of women, not law enforcement.
Well, you don't have to convince me about why immunity ought to be there. You don't have to convince me that the statute ought to give it to them. because that's what I thought. But would you at least recognize that there's at least some tension in your argument in what Agnes Scott too said? You would agree that for us to rule the way you want us to rule, we're having to parse what the Supreme Court said, right?
I disagree, Judge. I think that a ruling that Lieutenant Antonozzi or that Agnes Scott is not vicariously liable for the public execution of Lieutenant Antonozzi's duties is in no way inconsistent with what the Georgia Supreme Court said. All the Georgia Supreme Court says was he wasn't acting on behalf of a specifically identifiable state entity. That's true. I can't identify a state entity, and that's why there's no immunity under the Georgia Tort Claims Act. We're not talking about
who was he acting on behalf of then?
He was acting on behalf of the state when he's engaged in law enforcement, but there's no identifiable state entity. That's the purpose of the Georgia.
Who
Tort
could ever
Claims
be
Act.
liable? What other entity besides he himself personally then would a college ever be liable under your argument? I guess the answer is no, they would never be liable.
That's not true. So if the plaintiff can present evidence that Agnes Scott somehow directed, controlled, or otherwise interfered with his criminal investigation, substituted its judgment for his training and experience, then yes, there's potential vicarious liability there.
Of course, the evidence here is that maybe he should have reported, but he didn't.
And that's right, Judge, but reporting is different than
right.
Agnes Scott coming in on the front end and telling him how to
and
do his job.
usurping the role of the officer, which I think is some of the language. Justice Namias' decision in Hartley 2 uses the phrase mere licensure. And it seems to me that phrase kind of captures the difference between the way the Supreme Court saw it and the way we saw it in Hartley 1. And I suppose, and it seems to me, and I invite you to show me I'm wrong, that what you're asking us to do is kind of turn our backs on the analysis in Hartley 2 and just pretend none of it is there and reaffirm our analysis in Hartley 1 for this distinct issue.
I think, again, Judge, I respectfully disagree. I don't think that you are turning your back on the Georgia Supreme Court's analysis at all. All the Georgia Supreme Court said was that there's no immunity under the Georgia Tort Claims Act because there's not...
Yeah, I mean, you're talking about the narrow holding is distinguishable, but it seems to me that the analysis is your problem. Go ahead.
And again, I don't think that's true because they reached the analysis that you're not acting on behalf of a state entity. That doesn't mean that Lieutenant Antonozzi is not acting on behalf of the state when he's enforcing state law. And if he's executing a public function, then there's no vicarious liability. And I'm not here arguing that this is an immunity issue for Agnes Scott. This is a vicarious liability issue.
Right.
And the Georgia Supreme Court didn't take up the issue of vicarious liability. It didn't review the issue of vicarious liability in its opinion. All it was reviewing was whether there was immunity under the Georgia Tort Claims Act. And it's our position that because there was no evidence at trial that Agnes Scott directed or controlled Lieutenant Antonozzi's conduct, the denial of our motion for judgment, notwithstanding the mistrial, was in error. And if I may, I'd like to reserve...
I'll give you another minute, but I want to ask you another. I'd like you to address their argument that the statute relating to, I believe that the gender-specific languages in the statute, campus policemen, is different from the law relating to police officers of the Georgia University system and other law enforcement officers who are employed by the state or its subdivisions who are working part-time. The statutory distinction about campus policemen. Talk about that argument, please.
So I'm not sure I quite understand your question, Judge. Are you talking about in terms of vicarious liability? I mean, how
Well, that's the issue here, right?
It is, but specifically with campus policemen, I'm not sure I quite understand your question, and I apologize. Can you...
Not in the available time. I suspect you'll hear in a minute.
Okay. Thank you, Judge. And if I may, I'd like to reserve the...
Yeah,
my time.
give him 2 minutes for rebuttal, and so you have an extra minute and a half, sir.
Good morning, Your Honor. May it please the Court. My name is Lloyd Bell. I'm here on behalf of Amanda Hartley, the appellee in this case. All the questions have been spot on, and we briefed these in our briefing. Justice McFadden, you made the point that we made in our briefing, that there is a clear distinction between the status of the different types of individuals who are engaged in the tortious conduct. Specifically, these words mean something. The statute defines what a campus policeman is. Campus policeman means an employee of an educational facility whose duties include the enforcement of the laws of the state, preservation of public order, protection of life and property, prevention, detection, investigation of crime, or any combination. The authority of the campus policeman comes under 20-8-2. It says, on the campus of an educational facility, a campus policeman who is post-certified and, when authorized by the governing body or authority of such educational facility, shall have the same law enforcement powers, including the power of arrest, as a law enforcement officer of the local government with police jurisdiction. So our legislature has set apart a separate category of a public safety officer. They call them campus policemen. Campus policemen derive their authority from their employer. So Agnes Scott, in this case, they have complete authority whether they give some law enforcement powers to Lieutenant Antonozzi or withhold those powers from Lieutenant Antonozzi.
And that would be different, wouldn't it, from, I mean, if you work for the city of Savannah full-time and the Waffle House hires you, your law enforcement authorities do not emanate from the Waffle House, they emanate from the city of Savannah, correct?
That's correct, Your Honor, because when you're sworn in by the city of Savannah, you take an oath. You take an oath to support and defend the Constitution and enforce the laws of the state in a fair, equitable manner.
And here you don't get arrest powers unless the educational institution says you're authorized to have the arrest powers.
That's absolutely correct. And the only condition is that the officer has to be post-certified, which is, Justice McFadden pointed out from the Supreme Court opinion, is regarded as mere licensure. I mean, the state of Georgia licenses 45, I believe, different professions, including barbers and massage therapists. And the court made the point that that does not confer state immunity just by mere licensure. So all the cases, every single case cited by Agnes Scott are these dual capacity cases where you have a police officer, City of Savannah police officer in pounds, or a off-duty sheriff's deputy that is also working for a private employer. And the question always arises that when the tortious act is committed, is the officer acting as a public agent in which there would be immunity under the Constitution and the Tort Claims Act, or is the officer acting at the direction of the private employer? And that's where the analysis becomes very fact-specific as to what their role is. There's no confusion in this case. There's no dual capacity with Lieutenant Antonozzi. He works exclusively for Agnes Scott College. He was working for Agnes Scott College during all the tortious conduct that's at issue in this case. And Agnes Scott College doesn't have to be standing over his shoulder. I mean, we have many Agnes Scott College officials here. They don't have to be standing next to him and directing his conduct for there to be vicarious liability. The Callahan case cited in our brief talks about the long line of vicarious liability cases that say an employer is vicariously liable for the negligent acts of its employee, even if the employer doesn't know about them, and even if the employer has specifically forbade the conduct at issue, as long as the employee is acting within the course and scope of his employment.
But with the analysis, just a hypo that we were discussing before we came out, would the hypo be different if DeKalb County had also deputized the police officers on Agnes Scott and made them county officers as well?
I think it would be, Your Honor, because I think in that case you're dealing with a dual capacity situation. And the Supreme Court even left open a possibility that in some contexts a campus policeman may be regarded as law enforcement in some context. Now, the Supreme Court didn't define what those contexts were, but I think the example that you offered is a likely one. If Lieutenant Antonozzi was moonlighting as a sheriff's deputy and had been taking his public oath and could work in that capacity, that we might be dealing with the same situation in Pounds or Ambling or these other dual capacity cases. But he did. We keep hearing Lieutenant Antonozzi referred to as a police officer. Police officer is very specifically defined in the statute under 3542. Police officer means any law enforcement officer charged with the duty of enforcing the criminal laws and ordinances of the state or the counties or municipalities of the state, who is employed by and compensated by the state or any county or municipality of the state, or who is elected and compensated on a fee basis. That is not our situation. Lieutenant Antonozzi is not a police officer as defined by Georgia statute. He is a campus policeman whose activities, duties, responsibilities are completely controlled by Agnes Scott, his employer.
Where would the UGA or Georgia Tech Police fit in that definition?
Well, UGA is a state school, and there are distinctions that are.
But it's not a county or municipality of the state. I mean, if you're going to limit it just to those words, it's not those things.
Well, but it is a branch of the government.
But I'm just saying it's not what you're showing us right here. I mean, I think I clearly agree that they're entitled to immunity under the Tort Claims Act, but I'm just pointing out that it's not that definition.
Well, we have another definition that might be helpful, Your Honor. Law enforcement officer is defined. I believe this definition would encompass the UGA public safety officers. In this code, and this is 3517, a law enforcement officer shall not be liable at law for any action or actions done while performing their duties in an emergency except for gross negligence, etc. It says, as used in this code section, the term law enforcement officer means any peace officer who is employed by the state or any political subdivision thereof, who is required by the terms of his employment, whether by election or appointment, to give his full time to the preservation of public order or the protection of life and property. So I think under the law enforcement officer, the campus police for the state of Georgia schools would apply.
Isn't there a separate statute for campus police officers in the Georgia university system?
There is, Your Honor. There is. And that wouldn't apply here. It's undisputed that Lieutenant Antonozzi was a campus policeman. The legislature has not updated the gender, so it is specific to campus policemen. And it's undisputed that he was one of them. He was a campus policeman whose responsibilities were all defined by the employer, in this case Agnes Scott. So the bottom line point here is that we're talking about a private school, a private corporation that employs a full-time campus policeman who has enhanced powers because he has post-certification as determined by the employer. And it's not a complicated analysis as presented by Agnes Scott. He is not a policeman, he's not law enforcement, he is a campus policeman who has limited scope of activities.
So under the appellant's argument, a private college could never be responsible for a police officer who makes a bad arrest as long as they didn't direct him in any way to do that. Isn't that right?
That's exactly right, Your Honor. And I think the Supreme Court and Justice Namias sort of expressed that view in the context of the Tort Claims Act analysis, is that there is no accountability. And the reason that the legislature grants immunity to public officers is there's accountability. There's accountability through the ballot box, through public forum. You have a private corporation who's choosing which employees they're going to hire and also deciding which powers they're going to confer on that employee. To say we're not going to be responsible if they abuse those powers cuts off accountability.
In fact, I think arguably under those police officer and private setting cases, you might not even be able to hold them responsible if they hire the rogue police officer who hasn't lost his certifications that's been fired by every other municipality for being a bad police officer.
I think that's the logical extension of Agnes Scott's argument. I mean, it's a really straightforward case. Private company hired a public safety officer, decided to confer powers on this public safety officer, and he abused those powers. And of course, Amanda Hartley was on the receiving end of his abuse. And under their analysis and their sort of loose language, throwing around police officer and sort of pretending that Lieutenant Antonozzi is a government actor, it would cut off any line of accountability, as you pointed out, Justice Ray.
He would never have taken an oath of office. The process of being post-certified doesn't entail the oath to make you a sworn officer. That is something you take to the state or a subdivision, right?
Yes, sir. Post-certification is you go through a course and you establish or you show that you are qualified, minimally qualified, to be a law enforcement officer or a police officer. So once you complete the post-certification, they teach you search and seizure. They teach you the basics of being a police officer. So that is something that you can take and apply for a job with the county sheriff's department or municipal.
It means
police
nothing by itself. It's a license you take with you to go get employed. Right? I mean,
That's
you get no arrest powers from the certification. You get your certification card. You're qualified to then go take the oath with.
That's exactly right, Your Honor. I mean, it's we all, as attorneys, we're all licensed to practice, but we're not conferred state immunity by that licensure, or a barber or a massage therapist or any of the other folks who come under the licensing requirements of the state. So, so post-certification does not turn him into a state actor. Agnes Scott's counsel made the point or said that this really isn't a constitutional immunity case. Well, it's kind of a stealth constitutional immunity case, because what essentially they're arguing is that Lieutenant Antonozzi is a police officer, law enforcement officer. Well, that carries with it the constitutional protections under Article 1, Section 2 of the Constitution. And I just want to point this out quickly to show why it doesn't apply. The first paragraph deals with when their officers and employees of the state may be subject to suit if they don't perform their ministerial task or they're grossly negligent. The subparagraph, though, is the operative one. It says, except as provided in this paragraph, officers and employees of the state or its departments and agencies shall not be subject to suit or liability, and no judgment entered against them. So officers and employees of the state or its department and agencies. Clearly, Lieutenant Antonozzi is not an officer or employee of the state. The initial position of Agnes Scott was that the Tort Claims Act conferred immunity, and Justice Namias said that he tended to agree that the definition section of the Tort Claims Act would seem to suggest that there might be immunity. But he reasoned, and the Supreme Court reasoned, that if you take the entire statutory scheme together, that it did not work and did not apply under these fact situations. Justice Namias chose not to address the constitutional immunity argument because it wasn't raised by the parties at that time. But in this case, it is being raised, because in this case, by claiming Lieutenant Antonozzi as a peace officer or a policeman with the meaning that those words carry, that would allow them immunity. And the only way that the school can be responsible, their argument is that the school would have to specifically direct their conduct. That analysis is just flawed. It just doesn't. It's not supported by the facts. It's not supported by the statutes. So I'm going to go ahead and conclude, subject to any questions. It's our view, clear view, that Justice Panas, the trial court, was absolutely correct in denying their motion for directed verdict, notwithstanding the mistrial. It's our view that this cobbled together argument that vicarious liability in this case is completely different than every other case and shouldn't apply, we believe is fatally flawed. We would ask this court to affirm the lower court's order denying their motion for judgment notwithstanding the verdict. Thank you.
All right, Ms. Bennett, could you set that for 2 minutes? Whatever. Yeah, that'd be fine.
You said
We'll just
15,
watch.
I'll go to 13.
Right.
So, if I may address one point, Mr. Bell talks a lot about the employment. Who is he employed by? It's full-time. Lieutenant Antonozzi was full-time employed by Agnes Scott. But this full-time, part-time distinction, whether Lieutenant Antonozzi was employed by another state entity or not, doesn't make a difference. If you look at the Pound, and there's two reasons for that. One, the Pounds case makes no distinction. police officer in that case was appointed by the city of Savannah, but was employed full-time by the railroad in that case. And the Georgia Supreme Court...
was employed full-time. Tell me, what do you mean?
He was a full-time employee of the railroad.
But he didn't work for the police anymore?
He was appointed by the city of Savannah,
Okay.
worked full-time for the railroad.
he
So
didn't
his
work-
his police powers came from the city of Savannah, worked full-time for the railroad. And the second issue is that this is not a principle that is unique to police officers. In the Anthony v. American General Financial Services case, which is cited in our brief, talks about notaries. And the focus is on what is the employee doing. Are they acting in furtherance of the master's business? So police officer, if he's acting in furtherance of the state's business, there's no vicarious liability.
Tell me about the notary case, yeah.
Yeah, so that case involves a notary, and the question was, can a corporation be vicariously liable for the actions of a notary when that notary violates a notary statute? And the case dealt with whether notaries were charging too much in violation of the notary statute. And the Georgia Supreme Court in that case said corporation can't be vicariously liable for the violations of the notary because the notary was executing a public function. And when the notary is engaged in a public function, private corporation isn't going to be liable. So this is not a principle that's unique to police officers in this case. It applies to notaries, it applies to police officers, and the focus is what is the employee doing? Are they engaged in a public function? If so, you have to have evidence of direction and control before there can be vicarious liability for the private employer.
Thank you, counsel.
Thank you, James.
All right.